All right, welcome back, class. This is LGLA 1351. We are on week 12, right? Chapter 11 on remedies, and this is our recording number 2. We were talking about remedies. We had just started talking about compensatory damages, different types of money damages, legal damages, right? That you can get from the court. And let me go ahead and throw our PowerPoint back up. See if we can get this at the same time. All right. So we had talked about incidental damages. We talked about incidental damages, damages that are reasonably connected to a breach of contract, that flow directly from a breach of contract. The next category of damages is consequential damages. All right. It is often difficult to determine between whether something is an incidental damage or a consequential damage. Okay, consequential damages. The broadest definition is that incidental damages are damages that flow as a direct as part of the contract, right? Where consequential damages are damages that you suffer as a consequence of the other side breaching, but that's not very helpful. Consequential damages, maybe an easier way to think of it is incidental damages are not directly related to the subject matter of the contract, but they're much more closely related to the contract. Consequential damages are the farther farther removed damages that may result from a contract. Okay, they're not directly caused by the breach, but are due to the end result of the breach. Why do we have two different names? Well, because we treat them differently. The manner of proving incidental versus consequential damages can be a little more difficult. With incidental damages, you may remember from our PowerPoint that I don't even know if I mentioned it, but incidental damages, the law says you must be able to prove them with reasonable certainty, right? You have to prove that you actually lost these, that they weren't too speculative. But if you can prove, that here's the number, right? Here's the amount that I lost, Judge. Then if it's an incidental damage, it's easy to recover those. Consequential damages, you'll have to prove that not only do you have to prove them with reasonable certainty, but you'll have to prove that they were foreseeable, right? That this was something that the other side could have expected or could have anticipated would be the result of their breach. Okay. And so it's really more important on how the court is going to categorize them, because if the other side is fairly astute, they may point out to the court that there's a different level of proof required for incidental versus consequential damages. All right, but it is difficult to determine the difference a lot of times. If this was a law school class, I might give you a couple of questions on that and watch half the class miss it. I'm not going to do that here because even at the very smartest students in the very best law schools, half the time you're going to miss that one. It's difficult to determine. It really, my suggestion to you is you look at that at a case-by-case basis. You find some cases in your jurisdiction that distinguish between consequential and incidental damages. I will give you another cheat method for trying to help you determine whether something is an incidental damage or a consequential damage. And that is look at the UCC. We're going to talk about the UCC in just a minute. The UCC does not apply to every contract. Remember, we've talked about that dozens of times. But Article 2, Chapter 2, if you're in Texas, Article 2 that deals with sales has its own provisions on remedies. And Article 2 specifically provides for both consequential and incidental damages, and Article 2 actually has definitions and sometimes in those some examples of consequential or incidental damages. Now, the UCC may not apply to your case, right? So be careful. Don't take that too far. You may have to go look up other case law, but that is a good, quick, easy way to find kind of a cheat to help you kind of categorize whether something is incidental or consequential damages. Okay. The significant difference is if something is a consequential damage, then not only are you going to have to prove the amount of the damages with reasonable certainty, but you're also going to have to prove to the court that those damages were foreseeable to the other side at the time you entered into the contract. Okay. foreseeable to the other side at the time you entered into the contract. The idea there is one of fairness, right? If the other side had no idea that you would lose, I mean, they were selling you something for $5. They had no reason to believe that if they breached the contract, you'd suffer $50 million in damages, right? Then it's not fair to make them pay $50 million, right? They didn't think that. They thought this was just a normal contract. If they had known that you were relying on them to basically guarantee a $50 million contract, they probably would have raised that price a whole lot more, right? If they're going to be on the hook for those kind of damages, they're not just going to do that to sell you, some $5 component. So consequential damages, things that are more indirect, more removed, you may have to prove that they were foreseeable to the other side at the time the contract was entered into, not at the time that the contract was breached. You have to prove that they were foreseeable, not necessarily that they did foresee them and that they did know about them, but that they were foreseeable, that they could have known about them at the time they entered into the contract. Otherwise, you can't recover those consequential damages because the courts ruled that it's not fair. All right. So consequential versus incidental damages, we'll talk about it a little bit more when we get to the UCC remedies, because again, they're defined in the UCC, and that can be very helpful. Next category is reliance damages, okay? And it's important to understand that some of these categories can overlap, right? Reliance damages might be incidental damages, right? Reliance damages, there may be something that you could categorize as reliance damages, but you're like, that really falls under consequential damages, all right? So some of these categories can overlap, that's fair, but it's important to understand the different types and the different definitions so that you know what types of damages you can look for to make your client whole, all right? So this next category is reliance damages. Reliance damages are damages that are awarded for losses that the non-breaching party incurred in reliance on the contract. Okay, so if one party to the contract changes their position or incurs some kind of expenditure or incurs some kind of obligation relying on the other side following through on a contract, and then the other side breaches, then not only does the other side have to pay for damages, they may have to pay these reliance damages. Can I give you an example? Okay, how about this? I love teaching this class, and I love teaching it so much that I decided I want to apply for a position down at UT Law School down in Austin, right? I like teaching you guys, but I want to teach even more, so I'm going to apply to law school down at UT. But UT is down in Austin. It's not here in Dallas. And UT likes me, and so they offer me a job. And I can't live here in Dallas and work at UT every day, right? So what am I going to have to do? Pack my family up, right? Sell my house, move down to Austin, probably buy a new house. So let's say that I do that and I get down there and I'm excited. I go to my first day of class. And when I get there, my key doesn't work. And I go talk to the administration, and the administration says, oh, yeah, about that, we had some budget cuts and we had to cut your position. So no job. We know we signed a contract. Maybe we signed a 1-year contract, but no job. So we were going to pay you, whatever, $100,000 to teach for a year. You can sue us, but good luck. And I said, yeah, but it's not just $100,000 because I sold my house and I paid to pack up my whole family. And I paid all these moving expenses. I had to rent another place while I'm looking for that. I've got all these extra expenses on top of the money that I missed out on. Those would be reliance damages, right? I packed up my house in reliance on that contract. Or I incurred some other obligation in reliance on that contract, right? Maybe I applied to UNT and they accepted me into the school. Right. And so I went up and I leased an apartment for a year. And when I got to school, they said, oh, I'm sorry, we're too full. You can't come here. But we're not going to charge you any tuition. So you're not out of anything. Right. So go home and don't complain because you have no damages. Yes, I do. I have reliance damages. Right. I paid to move all my stuff up to Denton. I rented an apartment. Now I'm obligated to pay rent on the apartment for a year. All those things that I wouldn't have had to do had we not signed this contract. And UNT could say, well, we didn't know about any of that. None of that's directly related to the contract. You say, yeah, but those are reliance damages. They were expenses that I incurred specifically in reliance on you following through in this contract. So reliance damages. All right. Next concept to talk about is extremely important. It's this idea of present value. Okay, present value. And present value is based on this theory that money had today is worth more than money had in the future, right? And I can prove it. If I offer you either $500 today or $500 a year from now, who's going to take the $500 today? Every single one of you, right? Because you'd rather have it today than the same money a year from now. Why? Because $500 today you can do something with, right? You could spend it now, or you could put it in a bank account, or you can invest it, and then a year from now it would be worth more than $500. Whereas if you wait a year, all you're going to get is $500. So it's related to, we can think of this as the time value of money if you're a business major or you take economics classes. But the idea is that a dollar today is worth more than a dollar in the future. Why does that matter in a breach of contract case, and how does that apply to remedies? Well, because we've talked about things like incidental damages and consequential damages and even compensatory damages. If the damages that the plaintiff would suffer would be in the future, okay? If the damages the plaintiff would suffer would be in the future, then it's not fair to pay him all the money now, right? So let's say, let's go back to UT Law School. Let's say I signed an employment contract with them to work for them for 10 years, and they were going to pay me $100,000 a year. That's $1 million, right? But would I rather have $1 million now, or would I rather have $100,000 a year every year for 10 years? I would much rather have all the money now, right? Because I can put that $1 million in the bank and that money would earn interest, or I could put it in the stock market and it would earn interest. And 10 years from now, it would be worth way more than $1 million. But I'd be way better off than if they followed through on the contract, because there was no circumstance under this contract where I was going to have $1 million now. Maybe they pay me the first $100,000 up front, but then they're going to pay me the next $100,000 next year, and the next $100,000 the next year, and then the last $100,000 I don't get till 9 or 10 years from now, right? That $100,000 is worth way less than the first $100,000. Okay, and so it is up to the plaintiff to prove their damages. And if I sue the University of Texas Law School for $1 million for that lost salary, the court's going to say, okay, well, you proved that they breached their contract. You proved you had a valid contract. You proved they breached their contract, or they anticipatorily breached their contract, and they said, no, don't bother coming. But it's also your burden to prove your damages. And you didn't prove the value of your damages. You proved that they were going to pay you $100,000 a year for 10 years, but you didn't prove what that's worth today. Okay. And so, Watson, you get nothing because you failed to prove your damages. You failed to prove the present value of that future stream of income. Okay. So present value can be extremely important if you're talking about damages that would occur in the future. How do you prove up present value? Well, usually you've got to put on an expert witness, right? An accountant or an actuary or somebody like that. And the calculation is somewhat complicated. It's basically like figuring out reverse interest, right? So, you know, if you have $100 and you earn 5% interest a year, then at the end of the year, it's worth $1.05. Well, reverse present value is like working that in reverse, right? If you have $1 a year from now, if it had been invested at 5% interest, what do you have to start with? And it's not as simple as just going back, because it's if it's 5%, you know, $100 a year from now at 5% is not. It's actually worth a little more than $95. So the math gets a little bit complicated, and you have to have somebody who can put it on the stand and explain it to a judge or a jury. But it's basically a calculation that's kind of like reverse interest. You have to figure out what would be a reasonable rate for that to grow. What is the reasonable time value of money? And then you have to work it out backwards. So that is present value. And it is important to know if you are claiming a future damages or a future stream of income, something like that, that you reduce that to present value. Okay, because present value is all the judge can give you, right? He's going to give you one. He's going to order them to pay you one check right now. He's not going to order them to pay $100,000 a year for 10 years. And so you need to be able to reduce that to present value. All right, can be a little tricky. There we go. A couple of other concepts. Liquidated damages. What are liquidated damages? Well, liquidated damages are damages that where the amount of damages are not in dispute. Okay, the amount of damages are not in dispute, either because the parties have already agreed to them or because the parties agreed to them in advance. All right. Sometimes liquidated damages are obvious. We had a deal. I was going to sell you my car for $5,000. I gave you the car. You never gave me the money, right? So you owe me $5,000. Pretty simple. We may disagree on whether you owe me, but if you owe me, it's $5,000, right? The amount is liquidated. We know what the amount is. Other times, though, it may be that the parties agree to liquidated damages, right? We may put it right in a contract. Why would we do that? Well, think about it. Sometimes it may be extremely difficult to figure out what your damages would be, right? It would be extremely difficult to calculate your damages. And so the parties may agree in advance to set the amount, okay? Where we enter into a contract and we both look at it and we go, hey, the purpose of a contract is to define everybody's rights and to make things clear and concrete and to help us make good business decisions, right? And one of the ways it does that is it helps both of us know if one of us breaches the contract, what are we going to be responsible for? And sometimes the law on damages and remedies is clear enough, but other times, man, it may be really hard to figure out how I'm even going to prove my damages. And so as a result, we may enter into a liquidated damages clause that says something like, if one party breaches the contract, then we both agree that damages will be hard to calculate, and so so we'll fix the damages ahead of time at fill in the blank, X dollars. There's some important restrictions on, and so we see liquidated damages clauses in contracts all the time. But there are some important restrictions on liquidated damages clauses. Liquidated damages clauses can be very reasonable and very helpful. They can also be abused. Okay, they can absolutely be abused. So there are some restrictions in the law on liquidated damages clauses. Number one, liquidated damages clauses must at least appear to be reasonably related to the potential damages. They must at least appear to be a reasonable attempt by the parties to estimate what future damages might actually be. Okay, they've got to look like it was a reasonable attempt. Now, circumstances may have changed in the meantime, and that doesn't matter, but what the court's going to look at is when you all entered into the contract, was this a reasonable attempt to try to value those damages, right? And if so, then a liquidated damages clause may be enforced, it may be upheld. Second requirement is they must not be punitive, right? They must not be punitive in nature. So if I agree to sell you memory chips to build computers, right? You're Dell Computers and I'm Kingston. I agree to sell you memory chips to build your computers. And we both agree that, well, if I don't deliver those chips, it's going to shut down your assembly line. But who knows how many orders you would have in a given week? Who knows how many of those people would have ordered Kingston chips? Who knows if I'd be able to order some other kinds of chips? And that'd be difficult. So let's just agree that if you breach this contract, if you fail to deliver the chips or you fail to deliver enough, then for every chip you're short, you'll pay me, for every chip you're short each week, you'll pay me $5, right? Because that's the kind of damages that I might incur. That might seem reasonable, right? But what if we take that same agreement and say, okay, if you are one chip short, you owe me $1 million, right? Does that seem like a reasonable estimate of damages? No. Why would we do that? We would do that to make sure that Kingston delivers the chips, because if not, there's that big punitive $1 million liquidated damages clause, right? And if that's the case, then a liquidated damages clause that is merely punitive is not enforceable, okay? Let me give you a good example. And if you want to turn to our second to last week of class, right? We've got an exercise on there where I want you to look over that confidentiality agreement between Donald Trump and Stormy Daniels, okay? Take a look at that contract. What was that contract about? And let me start with that. I'm not here to give you my political views, right? This is not a politics class. This is a law class. And so, I don't want to see you guys throwing me up on YouTube somewhere complaining about my professors are radical is a radical left wing, a radical right wing, conservative or liberal. That dirty rat is trying to force his politics on me. My hope is to educate you all and that you all make good choices. Okay, but Donald Trump and a porn star is in the news all the time, right? And that's at least the kind of thing that might get your attention, that might get your interest, and that might at least be a contract that you're like, hey, contracts are pretty dry. If Watson gave me a contract between American Airlines and Texaco for fuel supply, I wouldn't be too interested. But the contract between Stormy Daniels and Donald Trump, I'll read that one. So that's one of the reasons I use it. Also, it's full of good examples, like a liquidated damages clause. What was the purpose of that contract, right? Donald Trump was getting ready to run for president, and he didn't want a porn star going around claiming that they had had an extramarital affair, because it was at least perceived that would not do his candidacy any good, right? So he wanted her to shut up about it. Now, did they have an affair or not? Don't know, don't care. But he definitely didn't want anybody talking about it. So he agreed, at least ostensibly the contract, he was supposed to agree to pay her money to keep her mouth shut, right? But how would you figure the damages if she breached the contract? So let's say he pays her $200,000 to keep her mouth shut, and then she goes and shoots off her mouth anyway. How is he going to measure damages? Are the damages just, well, you have to return the $200,000? Well, maybe, right? But that doesn't put him in the position he would have been in had the contract been completed, right? That just puts him back and it gives him his money back. That puts him back at square one. But how are you going to determine how much damage it would do to him if a porn star started making the TV circuit and saying that they had had an affair? Is it the damage to his marriage, the damage to his reputation with his friends? How would you put a dollar amount on it? What if it had cost him the election? How would you put a dollar amount on that? And so if you look, that contract contains a liquidated damages clause. It only goes one direction. But it says that if she breaches this contract, then it fixed an amount of damages. Does that seem reasonable? Well, sure. I mean, it could be. That sounds like one of those circumstances where it'd be almost impossible to measure damages. And so it's a great idea to try to measure those up front. And so we can put in that contract. So then we can both make a good business decision about, should I breach this contract or not? What's it going to cost me versus what are the benefits? So is that an appropriate place for a liquidated damages clause? Maybe. But take a look at that contract. You can find it in our class materials. That contract says, what are the liquidated damages? It says, well, if she breaches this contract, then every time she opens her mouth, she owes Donald Trump $1 million. What? One time, $1 million? What if she just told her best friend and her best friend never told anybody else, right? Then maybe Donald Trump's not hurt at all. Or alternatively, what actually happened, or what Trump claims happened is her lawyer then went and made the circuit across CNN and MSNBC and anybody else who would listen. And in one day, he breached the contract like 35 times. So did she owe him $35 million? He only paid her like a couple $100,000, or he didn't pay her. She was paid a couple $100,000. And so in exchange, because her lawyer shot his mouth off for one day, she owes him $35 million. Does that sound like a reasonable estimate of what his damages are? Probably not, right? What is the real purpose of that clause? That real purpose of that clause is to be punitive, to say, Stormy Daniels, if you breach this contract, I'm going to bankrupt you, right? I'm going to take everything you own and everything you ever earn in the future. You cannot afford to breach this contract. That liquidated damages clause is not a good faith attempt to try to fairly estimate what the damages are. Instead, the obvious purpose of that clause is to be punitive, to punish her if she breaches this contract. And as such, there is no court in the land that would ever have enforced that liquidated damages clause. It was, at least in a courtroom, it wasn't worth the paper it was written on, right? Is that why the lawyers put it in there? Did they ever think a court was going to enforce it? No. But they thought at least she'd be scared enough that it might ensure that she didn't speak up, right? Or at least if somebody else saw the contract, she told somebody else about it, she showed them, they'd be worried about, would they be on the hook for $1 million? So that's why they put it in there. but it was not ever going to be enforced by any court anywhere. All right, but that's a liquidated damages clause, or those are liquidated damages. Okay. Next category of damages: nominal damages. Nominal damages. Nominal damages are scary. Nominal meaning in name, right? Name. Nominal, just it makes an adjective. So nominal damages are damages in name only. Okay. Nominal damages in name only. Nominal damages are a minimum award of damages when a judge or a jury finds that the contract has been breached, but they can't identify or they can't put a number on the amount of financial loss. Okay, so nominal damages may be, and so you win your case, you prove that they breached the contract, but you didn't prove your damages, so you win $1, right, or you win $100. They're damages in name only. All right, so if you are a plaintiff, you do not want to see or hear anything about nominal damages. If you're a defendant, you love nominal damages. Nominal damages you lost, but now you really don't have to pay anything because they were awarded damages in name only. Does that happen? Sure, it happens all the time. It happens in like breach of contract cases, in cases where you're doing business with somebody or trying to do business with somebody. Like maybe somebody wants to borrow money from a bank to start a new business, and the bank defaults and doesn't loan them the money. And they'd like to sue for damages, and yeah, the bank agreed and they breached. But what are your damages? How much money you've never been in this business before. You have no way of knowing, no way of proving how much you would have made. You can't prove the damages that came from the bank of failing to loan you the cash. And so you may win a case against a bank, but only be awarded nominal damages. Let me give you another example of nominal damages. Again, from our good friend Donald Trump. I swear I'm not trying to pick on him. He's just ripe with because he sues everybody all the time. He's ripe with a bunch of good examples. He's also got some really bad lawyers from time to time. And so that also provides a bunch of good examples of legal issues. Donald Trump, he wasn't the only guy. He and a bunch of his rich friends decided to start, you may remember this, decided to start an alternative football league. Okay. The AFL, wasn't that the name of it? The American Football League instead of the NFL, the National Football League. They were going to start their own football league to compete with the NFL. And this is not a breach of contract case. It was a tort case, but there was still a nominal damages issue. So Donald Trump and his buddies tried to start this new football league. They entered into a bunch of contracts for stadiums, and they designed a bunch of, they set up a league, and they designed a bunch of jerseys and stuff. And they even recruited a bunch of players. Some of the most famous players that you've known, that you've heard of, started or were going to start in the AFL. But the NFL just did them dirty, right? The NFL committed a whole bunch of tortious acts and basically made them impossible. They killed that thing in the crib, right? They were able to put the NFL into bankruptcy, put them out of business before they ever really got started. Okay. And so not just Donald Trump and a whole bunch of the other owners sued the NFL for antitrust, for unfair business practices, for unfairly putting them out of business. The reason Donald Trump was involved, he was the representative plaintiff. He's the one that sat at the table to kind of represent everybody. He couldn't have all the owners there all the time. Not all the owners were talking to the press all the time. Who likes to talk to the press and be seen? Donald Trump, great. So Donald Trump was kind of one of the named, the representative plaintiffs. They went to trial. They proved up their case. And they proved that the NFL did a bunch of dirty stuff and just treated them bad, did them wrong. And the judge and the jury said, okay, congratulations, Donald. You and your friends, you win. You proved that the NFL did you wrong. But the NFL was bad people. They shouldn't have done that. And here you go. We award you nominal damages. Because even though you won your case, you have no way of proving how much money you would have made as a successful football league. You can't even prove that you would have been successful. You can't prove the United States can support 2 professional football leagues. And since you didn't offer any proof, or you didn't offer any acceptable proof of what kind of damages you would have made, you would have incurred, then congratulations, you win, but you only win nominal damages. So technically, Donald Trump and the AFL won that case. The NFL lost. Who do you think came out feeling like the winner? Obviously, the NFL felt like they came out like the winner because they didn't have to pay anything. And all that investment, all that stuff that Donald Trump and his fellow investors put into that case were lost. Now, this is a chapter on remedies. So what is the cautionary tale there? Cautionary tale is that at the very beginning, when you first take a case, you need to consider, is there a remedy? How can I get that remedy? And how can I prove that remedy? Because if there's no remedy at the end of the case, then this is all just a big waste of time. Okay, so remedies, so important, so important. Nominal damages, plaintiffs love nominal damages. Defendants never even want to hear the word nominal damages. Okay, nominal damages mean damages in name only. It means you're not really getting an award of damages. We'll award you $1 to show that you won, but that's it. All right. Last category, punitive damages. Punitive damages. We started this chapter by me telling you that breach of a contract is generally not considered good or bad, and that the purpose of damages was to make the plaintiff whole, not to make them rich, not to punish the defendant. The exception to that is punitive damages. All right, punitive damages are damages that are they're meant to punish. They are designed to punish. They're intended to punish. There's a statute that provides when you can claim punitive damages. The only purpose of punitive damages is to punish the defendant and to deter other people like the defendant from doing that same kind of thing in the future. All right, punitive damages, but they are only available in certain and limited circumstances. Okay, so punitive damages, yes, they're scary. Yes, they are outside the norm. And yes, we claim punitive damages in just about every breach of contract case, right? Every plaintiff's lawyer who's ever filed a breach of contract case has pled for punitive damages. Why? Because they want to scare the other side, because they want to get rich, right? But punitive damage claims, at least in breach of contract cases, almost never succeed. They're almost routinely thrown out of the court by the courts, either before you go to the jury or even preliminarily, like pretrial motions and that kind of stuff. It's thrown out. Because punitive damages are not typically available in breach of contract cases unless there was fraud. Okay, punitive damage is only available in breach of contract cases generally when there is fraud. Okay, and that fraud has't be at the inception of the contract. There had to be fraud in the creation of the contract. Okay, if you enter into a contract with somebody in good faith, and then a week later decide you're going to breach it, that's not fraud, right? You can't say, because fraud requires an untrue statement, right? And you can't say, well, you promised to pay me $5,000 and you didn't pay, so you must have been lying when you entered the contract. No, when I entered into the contract, I intended to pay you $5,000. That wasn't a lie. It was a week later when I decided to breach it. That's not fraud, okay? So punitive damages, we plead for them all the time. They are not limited to the plaintiff's damages, right? They can go way beyond the plaintiff's damages because they are intended to punish, right? They're more related to the defendant and their balance sheet, their finance, right? What would it take to punish this defendant? What would it take to punish this kind of behavior? But they are only available in very limited circumstances, like fraud. And it has to be fraud at the beginning of the contract, fraud at the inception of the contract, not something that happened later on, okay? Punitive damages. Some other types of damages, court costs, attorney's fees, those kind of things. Those come up from time to time, and sometimes they can be significant. You want to make sure you add them on if you can, especially in breach of contract cases. In the United States, generally, most jurisdictions follow what we call the American rule. The American rule is that it's not even a statute. The American rule is this idea that when it comes to court, everybody pays their own freight, right? If we have a car wreck case and I sue you for negligence, you pay your attorney, I pay my attorney. I don't get to claim attorney's fees. If you punch me in the eye, I might be able to claim punitive damages, but I can't claim attorney's fees. The American rule: you pay your lawyer, I pay my lawyer. Even if you win, whether you win or lose, the American rule is that generally all the parties pay their own lawyers, okay? But a common exception to that rule is in breach of contract cases. Almost every state, I haven't actually reviewed every state's law, so I can't tell you which ones do and which ones don't, but the majority of states either have a common law rule or have a specific statute that provides for an award of attorney's fees in a breach of contract case. Okay, so just about every state has some kind of provision that permits an award of attorney's fees in a breach of contract case. Now, be careful, because even though most jurisdictions have that exception that in a breach of contract case you can get attorney's fees, it can be very different from jurisdiction to jurisdiction. Okay, some states may provide just that attorney's fees are recoverable in a breach of contract case, and if that's the case, if whoever wins, if the plaintiff wins, he can recover attorney's fees. If the defendant wins and they've pled for attorney's fees, they can recover attorney's fees. That is not the case in Texas. In Texas, as in some other states, it is a very one-sided rule. Okay, in Texas, like some other states, attorney's fees can only be awarded to a successful plaintiff in a breach of contract case. Okay, but if the defendant wins, they don't get to claim attorney's fees. Okay, so in Texas, it's a one-sided rule. Only the successful plaintiff in a breach of contract case has to pay attorney's fees. If the defendant wins, the plaintiff's off the hook. He doesn't have to pay anything. All right. Now, that can lead to some difficulties, right? Oftentimes in a breach of contract case, both parties are pointing fingers at each other. So who's the plaintiff and who's the defendant? Sometimes it means it's very important to run down to the courthouse and file your case first, right? Really, you're the one who's at fault, and because you've told the other side you're not going to follow through. There's an anticipatory breach. They're threatening to sue you, but you don't want them to get attorney's fees too. So you rush down to court and you file a breach of contract case, seeking some kind of a declaratory judgment. You sue them first for breach of contract and you claim attorney's fees. And then when they come back and file a counterclaim against you, you say, no, judge, they're not the plaintiff. Now, judges sometimes see through that. That can get into some real mental gymnastics. But the point is, a successful plaintiff can claim their attorney's fees in a breach of contract case. A defendant who wins a breach of contract case is not entitled to their attorney's fees. All right. It is a one-sided statute. Now, another asterisk, another beware. Remember what we've said a number of times, even in this chapter, but also throughout the semester, is the terms of a contract control itself, right? A contract can control its own terms. You can provide differently in your contract. There's many contracts that, since they're aware of this unusual dichotomy in Texas law and how it's kind of unfair, one-sided, there's many contracts that have a provision on attorney's fees. You could have a provision that says even if the statute provides for attorney's fees, no side is ever going to be responsible for attorney's fees in a breach in a contract involving the breach of this agreement. You could do that and completely do away with breach of contract damages. More commonly, though, what the parties do is they just make it fair, right? They'll draft a contract that says in the event of a breach, the successful party can recover their attorney's fees. Okay, that way. You have amended the law, right? You've created additional rights beyond just the statute. That way, if a plaintiff wins the breach of contract case, they've got a right to recover their attorney's fees. But if the plaintiff loses, the defendant can recover their attorney's fees, kind of evening the playing field, making that fair, right? You want to see an example of that? Look up any of the TREC, the Texas Real Estate Commission. Look up any of their sales contracts. Their sales contracts have a specific provision in there to even that playing field. It says the successful party can recover their attorney's fees. So if a seller breaches a contract, the buyer can sue them. And if the buyer wins, they get their attorney's fees. But if the seller wins, the seller gets their attorney's fees. And with a TREC contract, it can even be broader. If the buyer sues the seller and they sue the agent and they sue the broker, they sue the title company, all these other people say, hey, man, we weren't even barely involved in this. Any of those parties who win, they can recover their attorney's fees, okay? So everybody's got some skin in the game because in that TREC contract, there's that extra provision that tries to balance the playing field. Otherwise, be aware that when people say, attorney's fees are always available in a breach of contract case, not necessarily true. Yes, that is a common exception to the American rule, but it's a one-sided exception in Texas, at least under the standard statutes, okay? But if you're filing a breach of contract case, you want to make sure that you also plead for attorney's fees, right? To make your client whole. That way, not only do they recover their damages, but they also can recover what they had to pay you. And in addition, court costs, right? Court costs generally not all that significant, but it can be a few $100 just for filing fees. Or there are some other court costs that can get terribly expensive, like copy costs and discovery expenses or expert witness fees. Sometimes those things are counted as court costs, and that can add up to a significant amount. So be aware, in a breach of contract case, you want to plead for court costs and attorney's fees if they're available to you. If you're drafting a contract, you want to be aware that that may be a possible remedy, that it may or may not be available under your state law. And even if it is under your state law, it may be kind of one-sided. So you may want to consider whether you want to even the playing field in your contract. All right, so that's attorney's fees. Whoops, where are we? All right, those are all legal remedies, right? Payment of money is a legal remedy, but we started talking about that there's also equitable remedies. And your book mentions a number of equitable remedies, so let's talk about these pretty quickly. The first one that your book mentions is called latches, L-A-C-H-E-S, latches. It's pronounced just like a door latch, but there's no T, okay, latches. It's not lache. I know some of this is Italian or kind of French terms when we see legal terms. Is pronounced latches. Latches is it's technically an equitable remedy, and so that's why it's appropriately in this chapter. But we can think of it more as an affirmative defense. It's really more of an equitable defense, a remedy that's available to the defendant. As a result, if you're a defendant, you think latches may apply, you definitely want to plead it because it's typically an affirmative defense. So you got to plead it and prove it. But what is latches? Latches is basically an equitable remedy. It's like an equitable version of the statute of frauds. Okay, I'm sorry, a statute of limitations. We have statutes out there that say you have to bring certain cases within a certain amount of time or you lose them, right? After so many years, you just can't bring these types of cases anymore. Well, latches is an equitable version of that. It doesn't rely on any particular statute, and so it has no real defined specific limitations. But the idea is, Judge, the plaintiff waited too long to bring their case. And as a result, I've been unfairly, my ability to defend myself has been unfairly affected. Okay, maybe limitations hasn't run yet, but they knew about this claim, 2 years ago. And they waited and they waited and they waited because they knew my key witness was very ill, or they knew that the evidence would somehow be destroyed. They told me they weren't going to bring a suit. And when they said, oh, no, never mind, we're not going to bring a suit, I destroyed all the files, right? And now they're suing. But for whatever reason, they waited too long. And because of that, now my ability to defend myself has been unfairly prejudiced. And so as a result, Judge, even if limitations hasn't run yet, you should throw their case out based on this equitable doctrine of latches. Okay, so it's kind of an equitable version of the statute of limitations. That's latches. Second type of equitable remedy your book mentions, we talked about a little earlier. It's called specific performance. Okay, specific performance is an injunction. It's a positive injunction. A specific performance is an order from the court requiring a party to actually do whatever it had promised to do. Right? If it's paying money, then that's money damages. But specific performance would be an order from the court requiring the losing party to do what they said they were going to do, or what the court ordered them to do, right? We see this a lot. I mentioned in real estate cases. The law deems that every piece of real estate is unique. And so if I was going to buy your house, I can't be put in the position that I would have been by buying another house, or by you giving me a different house, or even by you giving me money. That piece of real estate is unique. And the only way for me to get that piece of real estate is if you deed it over to me, right? And that's specific performance. So, Judge, I don't want money damages, or I want money damages too, but make them give me that house, make them transfer that house to me. And if they won't, sign the deed for them and transfer it to me. That would be an award of specific performance. So it's ordering a party to do what they were required to do under a contract. Now, you have to be careful on specific performance when you get into the area of personal services, okay? Personal services, if you require somebody to perform a personal service or to work for somebody, that begins to look a lot like slavery, okay? And we have not fixed, we have a history in this country, and we all know it. And you can be mad about it, you can deny it, you can say it should be taught certain ways or not taught certain ways, you can say it should be talked about or not talked about, you can say we should feel bad about it or not feel bad about it, but it exists, and it is a history that we face. Okay. And we do not allow slavery in this country anymore. And so there are a number of constitutional issues where, with a court or anybody else, requiring somebody to perform personal service. Okay. So that can be a limitation on specific performance. The court can force you to give me your house. But if Michael Jordan signs a contract with Nike to do some commercials, he signs a contract to do 5 commercials and he only does 4. Can Nike force him to do the 5th commercial? Can they order that specific performance? Maybe, maybe not, because that's requiring personal service. And that may start to look a little bit too much like slavery, which we do not allow in this country. All right. It seems that may seem like a stretch to you. And I agree. I mean, this day and age, you're like, no, he ought to just do his job. But it comes from those roots, right? LeBron James cannot be forced to play for any specific NBA team. That would be, if you tried to get an order of specific performance, the court's going to say, nope, that looks way too much like slavery. Now, they can prevent him from playing for any other team. They can order him to pay damages, but you can't get specific performance to compel someone to perform a personal service generally. Okay. Maybe making way too big a deal of that. Just want to make sure that you understand that's a limitation on specific performance. Otherwise, specific performance can be an extremely useful, an extremely powerful equitable remedy that you can seek. Right, you can really leverage the other side sometimes with claims for a specific performance. The third type of equitable remedy that your book talks about are injunctions. Okay, and we typically think of injunctions as court orders prohibiting a certain act. That's the way your book defines it. That is the way we generally think of injunctions, right? Injunction could be like a restraining order. Don't go near that person anymore. Or a restraining order. You signed a non-compete, so you can't go work for that other company, right? Michael Jordan, if you don't want to do commercials for Nike, we can't make you, but you can't do commercials for anybody else either, right? That's an injunction. Or hey, company, you stop doing business with his competitors because you promised not to, right? That would be a negative injunction, and that is an injunction. But injunctions can be positive. An injunction is just a court order ordering somebody to do or not to do something, and so technically, an order of specific performance is also an injunction. Okay, so just be aware. But yes, we usually think of injunctions as an order prohibiting certain acts, and if that's necessary to make your client whole, then injunctions are available in certain circumstances, like non-compete clauses, right? There's a great example. If I'm a dentist here in Dallas and I'm getting kind of old and I decide I'm going to retire, but I've got this big practice set up and I've got a big client list and that's valuable. I don't want to just let that go to waste. And so I sell my dentist practice to another dentist, right? But what's that other dentist worried about? He doesn't want me getting tired at the house, right? And just opening up a new dentist office right next door, 2 weeks from now. That suck all his business away. Then what he bought from me would be worthless. And so we might sign a non-compete clause, right? That I'm going to sell you my business, and in exchange, I won't open up another dentist office anywhere near you for a reasonable amount of time. And if I do, then you can sue me and get an injunction and say, no, Watson, you can go sell sandwiches or barbecue or something, but you can't be a dentist, at least not in this area, because you promised the guy you sold your business to. So we're going to give him an injunction. Restitution is another equitable remedy. Restitution is about returning property, right? If the defendant did something wrong and breached an agreement, something like that, you may order them to return property. Now, we often think of restitution as the payment of money, especially when we're talking about criminal law, right? Somebody makes restitution, by that they pay you money to cover your damages. Restitution is one of those narrow areas where it's an equitable remedy, but it could involve the payment of money damages. But it's not limited to money. Restitution may be returning something that you're wrongfully holding, right? Returning something that you're wrongfully holding. If you return something, if the defendant is ordered to return something to the plaintiff, something that they are wrongfully holding, that would be restitution, okay? There's also replevin. Replevin is about returning goods from one who is wrongfully in possession, okay? That doesn't mean that they necessarily wrongfully took the property. They are just now wrongfully in possession of the property. Let me give you an example of that. I had a client years ago who ordered a bunch of welding gases from a Chinese company, and actually from an American company. And the American company got them from their Chinese supplier, and the Chinese supplier put them on a ship and shipped them across the ocean. And while they were in transit on the way across the ocean, the supplier got a better offer. Somebody went to our supplier and offered to pay them double because the gas was so hard to get. Offered to pay them double, and so they agreed to sell our gas to another company, and we found out about it. And so we filed for a replevin. We filed to get the gas from the shipping company. Right now, the shipping company didn't wrongfully receive the stuff, but they had it, and they were about to turn it over to our supplier, who's going to turn it over to another buyer, or they were going to turn it over to the other buyer. So trying to get that stuff from the shipping company, or even if they had sold it to the other buyer, trying to get it from that other buyer because that specific product is ours, that would be replevin. Okay, so where you're actually recovering goods from someone who is wrongfully in possession. Right? Didn't necessarily acquire it wrongfully, but they're in wrongful possession, and I want my stuff back. Give it to me; it belongs to me. That is replevin, an equitable remedy. Last equitable remedy your book talks about is reformation. And that's kind of a declaratory relief, right? That's where you go in and maybe there's something unclear in a contract, and so you want the court to clarify it, right? That would be reformation, judge. Make this contract clearer. Or maybe there's a part of a contract that is unenforceable, right? There's a part of a contract. We talked about this when we talked about legality. There's a part of the contract that is now unenforceable. But the rest of the contract could survive. And so we want the judge to reform that contract by striking out the illegal portions. Remember, we would call that blue penciling, right? Because it used to be, before we had all these computers and word processors, that's exactly what we would do. We'd go through with a blue pencil and mark stuff out. That way you could see what was there. You could see the edit that was made, but you knew it wasn't included anymore because it had been blue penciled. In fact, if you know how to use your word processors, WordPerfect, all of them, they have those blue penciling functions to track changes. That's where the term blue penciling comes from. We used to actually use blue pencils to make those kind of additions. And that would be a suit for reformation, right? Maybe you're not suing for any kind of money damages. Maybe you don't have any money damages, but you need to clarify this contract, or the other side's insisting that you do something that is illegal, right? And you want to strike out that illegal portion. No money there, right? It's not a legal damage, not a legal remedy. But an equitable remedy, the remedy of reformation. All right. All right. Bear with me. We are almost done. But let's remember to talk about our good friend, the UCC. Okay. Remember, the UCC doesn't always apply to every contract. So the first question is, what law applies, right? You always got to start there. Chapter 2 or Title 2, if you're in another jurisdiction of the UCC, only applies to the sale of goods by or between merchants. So between a merchant and a merchant, or a merchant and a consumer. Okay, that's the sale of goods between two merchants, or between a merchant and a consumer. There has to be at least one merchant. It has to be the sale of goods. Otherwise, the UCC doesn't apply. All right, we've beat that to death. But if the UCC applies, you need to be aware that the UCC has its own remedy mechanisms. All right, now if we go back to remember the general purpose of the purpose of the UCC was to make commerce more smooth, right? So that merchants, so that people who were traditionally engaged in commerce would have a better idea of what their rights and their remedies were, so that things were more efficient, right? And so that they could do business and quit worrying so much about their lawyers. And so the UCC tries to make clear that the parties have certain rights, even without having to necessarily go talk to their lawyers or go talk to or go file suit with the court. The UCC remedies are split into a couple of categories. There's remedies for the sellers, sellers who are trying to sell something and the buyer breaches the contract or tries to rescind or anticipatorily breaches, right? And then there's remedies for the buyer, right? What if the seller doesn't perform? What if the seller performs, their performance is deficient? These remedies try to give a whole bunch of options so they meet all the different categories. I don't expect you to be an expert on any of them, but let's talk about a few of them, okay? In general, the seller's remedies in the UCC are covered by Article 2.703 And the title is Seller's Remedies, right? That's pretty easy. The section talks about, first of all, what if there's an anticipatory breach, right? If the what if the buyer has breached before the seller has delivered? What can they do? Well, the first thing that they can do is withhold delivery, right? The seller can withhold delivery. Now, under the common law, if the other side breached or they were about to breach or you weren't sure if they might breach, you had a question, were you going to withhold delivery? Because if you withhold delivery, could the other side claim that was a breach and so it excused their performance, right? So it could be a little unclear. You need to go talk to your lawyer. Do you need to file suit first or what do you do? The UCC says, nope, if the other side breaches, you can withhold delivery. That's just very clear, right? So if they don't pay for it, you don't have to deliver the goods, if that's what your agreement is. If your agreement was pay up front, they don't pay, you don't have to deliver the goods. You can take it a step further. You can stop delivery, right? If you've already delivered the goods to a bailee, right? That's a term of art, bailee in contracts. A bailee is someone who is holding the goods. They don't claim a right to them, but they're holding them. So that's typically like a storage facility or oftentimes a transportation, right? They're on a truck. You have delivered the goods to a bailee, to a trucking company. The trucking company is now on their way to the seller. To the buyer, but the buyer hasn't paid. So the seller can instruct the bailee to not deliver or to deliver somewhere else, okay? They can proceed under the next section. We'll talk about that one a little bit. They can resell and recover damages, right? So if, let's say you've got a contract to sell oranges to a grocery store at, a ton of oranges at $1 a pound, right? So $2,000. And you find out that the seller's gone out of business or the seller says, hey, I don't want them after all. What do? Do you just bring those oranges back and dump them in the trash and claim $2,000 worth of damages? Well, maybe. But we've talked previously a little bit about this idea of mitigation, right? And that sellers not only have a right to mitigate, but a duty to mitigate. And that's what this section covers, is mitigation, right? So you got a contract to sell oranges to a grocery store for $1 a pound. They didn't pay, or they've said they're not going to pay. They've breached the contract. You can divert those to somebody else and sell them over there for 80 cents a pound, right? You can sell that to mitigate some of your damages. So that's a right that a seller has. You can recover damages for non-acceptance under 2708. We'll talk about that one and why that's a little bit different. Or in a proper case, sue for the price, right? Sue for the price. Well, we had a contract to deliver a ton of oranges for $2,000. You didn't pay, so I'm going to sue you for $2,000. That is available in the appropriate case. What's the appropriate case? Well, the appropriate case would be like if you don't really have any other opportunity to mitigate those damages, right? Let's say Donald Trump orders a bunch of MAGA 2024 hats, right? He orders $1 million worth of MAGA 2024 hats. And then he decides not to run. He announces he's not running. Well, who wants them? I've got all these printed hats, nothing I can do with them. So what do I do? Well, in that case, you would probably sue for the price because there's nothing else you can do with them. And then number 6 is you can just cancel the contract. We consider that rescission, right? If the buyer says they're going to breach the contract or they do breach the contract, you can just cancel the contract. Forget damages. Just say, you know what? We're going to cancel it and walk away. You breached the contract, so I'm going to rescind it. I'm going to cancel the contract. Those are your options under 2703. There's a couple of different sections then that talk about, well, okay, if you exercise one of those options, what are your damages? And there's a couple of different measures for damages. One would be resale, right? If you can mitigate your damages, if you can resell the goods somewhere else, then you can do that and you can recover the difference. So the oranges, right, I was going to sell them for $2,000. You wouldn't take them, so I sold them to somebody else for 80 cents a pound. That's $1,600. I can do that and sue you for the $400 difference, right? You can sue for the difference in the price. What if I was supposed to sell them to you for $2,000 and you didn't take them, so I sold them to somebody else for $2,500? Then what are my damages? Then my damages are negative $500, right? I didn't actually lose money. I made money. So I don't have any remedy. I don't want to sue you, right? Because I actually made money. There's the benefit of the bargain damages, and this can be different. Benefit of the bargain, you can sue for the difference between the contract price at the time it was supposed to be performed and the market price. This applies when there's a particular good that has a recognized market, okay? So if I had a contract to sell you oranges for $2,000 for $1, a ton of oranges for $1 a pound, and you breach the contract. Well, then I can say, okay, the day you breached the contract, the price of oranges was actually only 80 cents a pound. I had a contract with you to sell them for $1 a pound, but the market price was only 80 cents a pound. So I'm going to sue you for the difference. Why are there two different categories there? And this is important, or it's at least interesting. Because maybe I can't sue you for the resale, right? The difference between what I actually sold them for and what I contracted for, because maybe I don't know which oranges were yours, right? I've got a whole warehouse full. I got a whole orchard full of oranges. I was going to sell them to you, and make money. But when you rescinded, I don't know which ton of oranges I was going to sell to you. So I can't tell you how much I sold your oranges for. So I can't tell you the difference. All I can tell you is, well, on the date when you rescinded, the market price was actually less than the contract price. And so I lost money, right? So that's the difference. So you would sue for the benefit of the bargain damages, the difference between the contract price and what the actual market price was, right? That's the benefit of my bargain as a seller. I cut a good deal. I got you to agree to pay 20 cents a pound more. I'm entitled to that benefit of the bargain. All right. Section 2709 talks about the price of the goods. And the price of the goods, I just gave you an example of that earlier. First of all, if the goods have already been delivered, then obviously you can sue for the price of the goods, right? I delivered 2,000 pounds of oranges. I don't care if you want them or not. I delivered them. You got them. Pay me the money. Okay. So you can sue for the price of goods then. But you can also sue for the price of the goods if the prices can't be resold, if there's no market for them, if they're unique. MAGA 2024 hats, for example, or you're building cars and you ordered me to build a specific type of taillight for your car. It doesn't fit any other cars. So if you don't want them, who am I going to sell them to? They're worthless. So under those circumstances, I could just sue for the contract price, right? So I've got 1 million, taillights to Dodge Chargers, but no other car uses them, and so there's nobody else I can sell them to. So you could sue for the contract price. Then, and this is beneficial, the UCC talks about incidental damages, right? We talked about incidental damages under just kind of general principles of common law. And the UCC says that you can recover incidental damages in addition to these other types of damages. Okay, so in addition to these other types of damages, you can recover incidental damages, which the UCC specifically defines as shipping and storage and other related expenses, right? Those things that are directly related to the breach of the contract, right? So I was going to deliver the oranges to you. You contracted $1 a pound. You breached, so I sold them to somebody else for 80 cents a pound. Well, great. But I also had to pay extra to ship them over there, right? Or I had to pay extra to store them for an extra day. And then I had to pay extra to ship them over there. So if you just give me that 20 cents a pound difference, I'm not going to be made whole. I also need to be covered for these incidental damages, these extra storage or shipping expenses. So that would be an incidental damage. That's also a good example of what I told you. If you're looking at common law and you're trying to decide whether something is incidental or consequential damages, look at those UCC definitions. They can be very helpful. Just remember, those UCC definitions only apply when the UCC applies. And so if the UCC doesn't apply, while you might use the UCC terms as a cheat sheet, you're still going to want to go research your common law and see how your jurisdiction specifically defines incidental versus consequential damages. Okay, so those are the seller's remedies. Buyer's remedies go the same way. First, section 2711 talks about generally what a buyer can do. And then there are separate sections that talk about, and so what can they recover because of it, all right? And it's a fairly long, both of these are fairly long mechanisms. They can take weeks to learn in class, and we don't have weeks to spend on remedies. It's just one day. So if you don't get it all the first time, that's okay. Be familiar with it and know now you can go look up these statutes, read them yourself anytime. My suggestion to you when you look at these UCC sections is read them all, right? Because they're circular. Until you understand the whole thing, it's kind of hard to really get a grasp of any of it, okay? So if it becomes an issue, go check out the sections of the UCC, read them specifically, and read all of them so you can see generally what your options are, what your damages are, and then connect everything back together, okay? But when it comes to buyer's remedies, the buyer's remedies generally under 2711, the first one is that buyers have a right to cover. Okay, they have a right to cover. And what does that mean? It means If the buyer has a contract for certain goods and the seller doesn't deliver them, the buyer can go get those goods somewhere else, right? That is the right to cover. Can they sue for damages? Sure, but that's the next section. The measurement of the damages is another section. The first right that they have is to cover, to go out to find replacement goods to cover them, and then to sue for damages under one of the next sections. We'll talk about those. The second thing they can do is recover for damages under Section 2713. That's another section that talks about damages. We'll get to it. There are some other things that a buyer can do. Under Section B, if there are certain goods that have already been identified to the contract, right, then the buyer can sue for those specific goods. This would be the common law idea of replevin, right, or replevin. That'd be a good example of that case that I talked about where we ordered a bunch of welding gases, right? We had a bill of lading. The company that we ordered from had given us a bill of lading that said, your cylinders, your gas cylinders are on this specific ship from China. Here's the number. They're in this crate. Those are your cylinders. And when they breached the contract, when they said, well, you're not getting them, we sued for replevin. We sued for this idea under the UCC that we could recover those specific goods because they'd already been identified to this contract. All right. And that's related to subsection 2, which is you have a right to specific performance or replevin, and again, damages as set forth in the next chapter. Okay, so the next sections. So this idea of recovering the actual goods that have been identified to a specific contract, or more broadly for replevin or specific performance, you can bring suit for those under UCC as the buyer. Buyer's got some other options. What if the seller has delivered the goods, but they don't meet the terms of the contract, right? Then the buyer has a right in a reasonable time to reject the goods, right? But if they reject the goods, do they have to give them back? Well, if they've already paid, if they reject the goods, now they've paid and they've got nothing. So under Section C, they have a right, if they reject the goods, to hold on to them as security in the meantime to see if the seller is going to make good, if the seller is going to actually cover by delivering conforming goods, or if the seller is just going to walk away, right? They may not want those goods, but it's better than nothing. So if they rightfully or justifiably refuse to accept goods or reject goods or revoke acceptance after they've accepted them, but then they decide, wait, we discovered something. If they do that rightfully, then they can hold on to the non-conforming goods as security. And if necessary, they can even sell them, right? So I ordered oranges, you delivered tangerines. I don't want tangerines. Nobody in my store will sell tangerines. Nobody in my store will buy tangerines, but I'm going to hold on to these to see if you deliver oranges. And if you don't, well, there's another grocery store on the other side of town. I can sell them to him wholesale. He'll pay half of what I paid. That helps me recover some of my damages, right? So you have a right to hold those non-conforming goods as collateral, and essentially dispose of them in a reasonable manner if the seller continues to remain in breach of the contract. All right. All right. The buyer's damages, very similar to the plaintiff's damages, right? We have a benefit of the bargain. They can sue for the difference between the contract price and the market price. We already talked about that with the seller. Well, the buyer can do the same thing, right? Maybe the buyer doesn't just order oranges from you. They order so many oranges that sure, they bought more oranges, but they can't tell which ones they specifically bought to cover your shortage. All they know is what they pay for them on the market. So if the market price is higher than the contract price, the buyer can sue for that benefit of the bargain damage, that difference between what they had to pay for them on the market and what the contract price was. And they can sue for that even if they didn't cover. They don't have to prove that they went out and bought them. They just have to prove that they had a contract, you breached it, and there was a difference between the market price at the time of performance and the contract price. They don't have to prove that they actually covered. That's their damage, their benefit of the bargain damages. They're entitled to sue for that. If the seller did deliver something, if the seller delivered non-conforming goods, then the buyer can sue for the difference between the value as contracted and the value as delivered. Okay, so if what you delivered is not worth as much as what you promised to deliver, then the buyer can sue for that instead. So let's say that you were supposed to deliver 1,000 pounds of oranges at $1 a pound. You only delivered $800 of oranges at $1 a pound. They could sue you for $800. That's a difference, right? Because you were supposed to deliver 1,000 pounds at $1 a pound. That's $1,000, and you only delivered 800 pounds at $1 a pound. So there's a difference in the value contracted and the value as delivered. But it might not just be quantity. Maybe it's quality, right? I ordered oranges and you delivered tangerines. Well, you might consider tangerines as oranges, but they're worth less. And if they're worth less, then what you delivered is not what you contracted for. Or I contracted for grade A eggs, grade AAA eggs, and you delivered these grade B eggs. Grade B eggs they're not worth as much as grade A eggs. So I'm going to keep the grade B eggs. I'm going to sell them, but I'm going to sue for the difference between the value delivered and the value as contracted for, right? Or maybe just what you delivered were, they were defective. They were just lower quality. I mean, I used them because it was the only way I could conform with my other contracts, but the value was just less. And so I'm going to sue for the difference between the value as received, what is the value what you actually gave me versus what is the value what you were supposed to give me. Okay, that's a buyer's remedy. And then again, just like the common law, just like the seller's remedies, the UCC goes and defines incidental damages, right? Those are the shipping and storage related damages, those things that are kind of incidental to the breach of the contract, and consequential damages, those damages that naturally flowed but are more removed. And again, just like in the common law, the UCC requires that if you're going to claim those consequential damages, that those damages had to be foreseeable at the time of the contract, and you have to prove that. Okay, so buyer's remedies, seller's remedies under the UCC all make a lot of sense. They're all very similar to what you could get under the common law, except they're set out in the statute, and so you specifically know what you're entitled to. You don't have to wait around for your lawyer or for the court to award them to you. Under the statute, you are specifically permitted to do these things. All right. Now, your book mentions this difference between contract and tort law. It is important again to understand. I started by pointing out that a breach of contract is not necessarily an evil, right? It's just business. But sometimes, a tort, sometimes certain conduct may bleed over from a breach of contract to a tort. Okay, what is a tort? A tort is a breach of a social norm or obligation, right? Breach of contract is a breach of a specific right you have under a contract. A criminal violation is a violation of a specific criminal statute. Torts are in the middle. Torts are those violations of societal norms, things like a negligence, right, or assault and battery, right? That can also be a crime if it violates a criminal statute, but they bleed over into these societal norms. And sometimes breach of a contract may also look like a tort. And if that's the case, then what do you do? Well, as the plaintiff, you can pick, but you have to pick. Okay, if something might be a breach of contract, but it might also be a tort, you can sue for breach of contract, or you can sue for the courts, or you can sue for the tort. Sometimes you can sue for both in the alternative, okay, but you can only recover for one. Okay, so if a breach of contract is maybe also is negligence, you can try to plead for breach of contract and in the alternative for negligence. But if the judge or the jury decides that yes, it was both a breach of contract and negligence, you only get one reward. You only get one award. You can only recover for the breach of contract or the negligence, not both. Okay, and it really goes back to this idea that the purpose of remedies in contracts is to make the plaintiff whole, not to make the plaintiff rich, not to punish the defendant, but to make the plaintiff whole. So the plaintiff only gets one recovery. If it's a gray area where tort law and contract law, overlap, then you may be able to at least try both. Because what if you sue for breach of contract and lose, but you would have won under the tort? Or what if you sue for torts and you lose, but you would have won under the contract? Most jurisdictions, the rules of procedure will allow you to sue in the alternative. But if you win both, you have to select. You only get one recovery. Okay. So that is it for remedies. That's a lot. And we've covered a lot of things for beyond remedies. We talked about we started talking about some alternatives to remedies, and we talked about common law remedies, and we talked about real quickly about these UCC remedies and about these mechanisms where buyers and sellers can go out and decide what's good business before they even talk to their lawyer, right? Am I going to keep this stuff and resell it and sue for the differences? Do I have to give it back? What if they don't deliver at all? Can I go back and can I go out and buy something to replace it, on the market? What are my damages? Those are all things that merchants can decide themselves under the UCC, so they can make good business decisions. But remedies are so important, because if you don't have a remedy, if you don't know what remedy you're looking for, if you can't prove your remedy, then a lawsuit is really a waste of time, right? And so remedies are very important. It'd be nice to put those at the beginning of, you should be considering remedies at the beginning of every case. It'd be nice to put those at the beginning of the book, at the beginning of this course, right? It would just be hard to understand without a context. All right, so we're talking about it now. If you have any questions at all, please first take a look at my class notes. Those lecture notes cover most of this, the same stuff that we talked about in class, and I hope that they're helpful to you, and I hope you can find them on campus. If you still have questions, though, please give me a call, shoot me an email anytime, or check the schedule. Come to one of my other live classes. I'm happy to talk to you before or after class. Okay. All right. That's it. Like I said, if you got any other questions, give me a call, shoot me an email, stop by class. Otherwise, you got a couple assignments this week. Get those done, and I will see you next week. Thanks. Bye.